come through like normal.
Good evening, members, and welcome to this Policy and Resources Committee meeting of the 22nd of May 2019. I've been advised that there are no fire drills planned for this evening, but if an alarm does sound, then Mr Nash, to my right, will assess the situation and provide further instructions on the evacuation of the building if necessary. I would remind you that this meeting is being broadcast live and recorded for playback on Maidstone Borough Council's website. But will anybody else be recording or filming the proceedings? Councillor Mackay has noted. I ask only so that people at the meeting know that this will be happening if it does occur. Members who are using mobile phones or tablets are asked please to ensure that these are on silent and are only being used with regards to the business on the agenda this evening. So I'll move to agenda item 1. Apologies for absence have been received from Councillors Clark and Mortimer and Burton, I believe. So agenda item 2, notification of any substitute members. Councillor Joy first.
Councillor Joy for Councillor Mortimer.
Councillor Vizard.
Councillor Vizard for Councillor Clark.
Councillor Garton.
And Councillor Garton for Councillor Matt Burton.
Thank you very much. Agenda item 3, there are no urgent items, so I'll move to agenda item 4 and pen poised for notification of visiting members. So would you please, in a queue, just approach and just say which member you are, where you're representing, and obviously there's only one item, so just so we can note who's here, please. Thank you. Next, please. Yeah. You're in the wrong room, isn't it? Thank you. Thank you. Thank you. Councillor Springett.
Could I raise a point of order, please? Sometime last year, I raised the question as to whether I was on JTB and there was an item on there that I had an interest in, so I asked if I could have a substitute attend on my behalf, and then I attend as a visiting member, and I was told no. If I was on that committee and in the chamber, I had to take my seat. So could I seek clarification, please, because I was not allowed on that occasion to do what Councillor Clark is doing.
I asked exactly that, so I will pass over to legal representation here, please.
Council Procedure Rule 5 outlines the position regarding visiting members. If a member is on the committee and has decided for any given reason to allow a substitute to attend for any reason, then the substitute attends as a committee member, and the visiting member will, the committee member that is now attending as a visiting member will be seated with the other visiting members. I think that would be appropriate. The rule, Procedure Rule 5, doesn't go into detail as to whether they sit with the committee or not. I would have to consider the specific terms for that particular committee that you're... Yeah.
It was an issue that I had where I had to declare an interest, so I was unable to sit on JTB, and I asked if I was able to have a substitute sit and attend exactly the same as a visiting member, and I was told I was not. If I was present in the chamber, I had to take my place on the committee, and I was unable to attend the meeting. So it wasn't a planning committee, it was JTB. So I appreciate you'll make your decision tonight, but I would like a review done as to whether I was incorrectly stopped from attending as a visiting member last year. Thank you.
Thank you very much. That's noted. We'll bring that a decision back to you either in writing or at another meeting. Thank you. Okay, that was agenda item 4. Agenda item 5 then, disclosures by members and officers. I see Councillor Pearl indicate first.
Thank you, Chairman. I'd just like to disclose that I'm an owner-occupier on St Peter Street, and item 10 obviously proposes to cram about 900 flats on my street, so I thought I'd just disclose that. I can just assure the committee it will not impact my comments one jot.
Councillor Clark. Thank you.
Can I just clarify a point? If a member is sitting on the committee as a member, then dispensation would be appropriate. But as a visiting member, you're perfectly entitled to comment on the agenda item. Thank you.
Because you're not going to be voting, so... Okay, I didn't turn to my left and look to any officers, so just accept that no. So everybody else has declared. Thank you very much. Right, agenda item 6, any disclosures of lobbying? Thank you. Okay, None. Sorry, Councillor Gooch.
I'm sorry, Chairman, I should have said I have been lobbied on one of the items on item 10. But I won't disclose which item that is until we come to it.
Okay, thank you very much. Agenda item 7, I propose that we take agenda item 10, call for sites in private due to the possible disclosure of exempt information. Is this agreed? Sorry, I heard somebody say that.
Chairman, I've moved that this matter be taken in public. It may potentially be exempt information, but it is not confidential information. It's clearly a matter that will be of some concern to constituents. It also concerns a number of sites which, with respect, are not confidential because they've already appeared on the front page of the Kent Messenger. I would strongly suggest that this is a matter of some interest amongst my constituents.
Councillor Garton, is it relevant to the same thing?
Along the same lines, we've just had an election. Prior to the election, just less than 2 or 3 months ago, the council has produced an inventory of sites belonging to the council and of properties belonging to the council, and we were given assurances that it's merely an inventory. There's nothing which is of any contention, and we're not concreting over any playgrounds. I think in the public interest, and there was a lot of press coverage about that at the time, I think in the public interest we should hear this in open house tonight.
Pass to Patricia Nairborn from Legal.
As indicated, Chair, as indicated on the first page of the exempt item, the Local Government Act does enable the council to treat some information as exempt. In this instance, it's because the local authority itself has property interests. I mean, we don't know in terms of the precise negotiations we may enter, and also some of the interests belong to third parties. So we are obliged to keep not only the local authority's property interest and our negotiating ability confidential at this stage, so that we don't compromise negotiations to be entered into at a later date. But we need to protect third-party interests as well. And there are particular processes that we need to undertake, for example, consultation with the public at particular stages. So when we treat particular items as exempt, we do apply the public interest test before we allow officers to treat the item as exempt. And we've undertaken that exercise. I appreciate the need for the public to be fully aware and for the council to be transparent, but those are all matters that we take into account before applying the test. Thank you, Chair.
Councillor English, then back to Councillor Pearl.
I'm aware of the legal framework which allows us to do that, but one would normally expect there to be considerably more financial detail for something to be kept exempt, particularly or more precise site definitions or a combination of both. Given that I understood that fairly rapidly and that the reason for this meeting being so quickly arranged was that we had a call for sites deadline and that this had to go to SPI fairly quickly, I'm struggling to see what the need for confidentiality is, because in order to prepare the agenda for SPI, if we do have a call for sites, any of these sites in here will have to be on that agenda in the public domain, otherwise that committee will be unable to make any determination. So given the very short timetable, I am not seeing what the need for confidentiality actually is, because these are going to be all in the public domain, assuming we don't take any of them out, within a few weeks. Unless the reason for having this emergency meeting and these reports was misreported, because surely the entire point of meeting so soon after the election was because we had a deadline.
Chair, it's not only the need to detail, it's not only financial information that amounts to an item being exempt. For example, property valuations may be relevant in terms of if a site is going to be called for a particular use, or particular restrictions are going to be imposed, or something's going to happen to a property. It may, I'm giving you examples, and there are reported cases on this, and it's not uncommon for local authorities to treat reports like this as exempt or confidential and to be released at a later date. The guidance has been provided. I'll pass over to the Chief.
I'd like to add two things to the advice that you have already received. Reference has been made to the sites that we own, to the sites where we have been developing guidance, and no reference has been made to the third type of site in this report. I'm choosing my words very carefully, and we may need to go into part 2 for me to give you further advice on that. In considering these sites, particularly those where we do not own the land, in order for you to come to a conclusion on the merits of us submitting information as part of the call for sites, we will need to share with you information that it is not appropriate to have in the public domain at this point in time. That does not conflict with the later consideration of the policy guidance for regeneration sites. And with respect to the category of sites that I am not going to name, we are in a position where we have highly sensitive, very confidential information that will become apparent when you consider that particular proposal. If you decide to take the whole of this report in the public domain, we will not be able to advise you fully on either the regeneration sites or the other recommendation in this report. I'm not prepared to say anything further unless we do go into part 2, just for giving advice, and then you can make your own conclusion. But certainly I am not prepared to advise you on some of the aspects of this without being in confidential session, because we have information from landowners that it's not appropriate to put into the public domain at this point in time.
Okay, I will allow Councillor English to come back, and then I had Councillor Pearl and then Perry indicate.
I think that does put a slightly different complexion on it. Certainly, I don't think any of the information in the report, just as it stands, justifies going into part 2. But on the basis of what you've just said, I'm prepared to waive judgment for the moment and accede to your advice. But on the basis that if it really doesn't apply, I reserve the right to come back. But at this point, I'm willing to follow your advice, Madam Chief Executive. Councillor Pearl.
I would just make a few points on this. I'm grateful for the references to Schedule 12A of the 72 Act. I would refer you to paragraph 9 of the same, which says that if an item concerns a matter that a local authority may grant itself planning permission on, it is not an exempt item. I'd also refer you to the distinction between exempt and confidential information. The principle of exempt information is that we are not obliged to disclose it, but we may if we wish to. The third point, and picking up on the issue that Chief Executive has just raised and which Councillor English has followed on. As Councillor English points out, there's not actually much in the report itself that warrants treatment of this matter as confidential. Might I suggest we split the discussion between part that we hold in public and part that we go into part 2 on, in order for the more interesting items to be discussed in that.
Thank you. I'd like to hear from Councillor Perry.
Thank you, Chairman. Yeah, I was looking at the paper itself, and it didn't seem to have anything on it that seemed terribly confidential, particularly as the call for sites itself ends on the 24th of May. So we're right up against the deadline. I'm not quite sure why we've ended up coming so close to this general deadline. I try to understand what has been said, but I just want to make the point that the paper itself doesn't seem to have anything on it that's particularly confidential. I mean, a lot of it's in the local plan. A lot of it's been previously discussed at any rate. And a lack of transparency in these discussions in the past, particularly in a local plan issues, has got us into a lot of trouble in the past, and particularly with interested parties and residents. And so I'm concerned that we're going down this road, and I would much prefer to have an open discussion. If it means splitting the paper up, as Councillor Pearl has suggested, I can go along with that. But I am very concerned that we are going down this confidential road and using the yellow papers every time. We seem to have something that slightly scares us. We go down the confidential yellow papers rule, and I don't like that. We should be looking the other way and trying to be as transparent as possible. Thank you.
Chief Exec, please.
Okay. As I'm sure you'll appreciate, there are occasions where we do brief the leader and group leaders. And we certainly have done so on the background and the issues, some of the issues that are raised in this report. All group leaders know that this council has signed non-disclosure agreements with some of the landowners to whom these sites refer. Because of that, I am not prepared to provide advice to you on those items in public. Councillor Perry knows about that, and so do the other group leaders. The area where I can see some of an argument around this, and I may be more marginal, relates to our own sites. But I would just reiterate the advice that you've had from the monitoring officer, which relates to the commerciality of considerations for the future of those sites. If you wish to take those separately, then the position, I'd still advise against it, but I don't think would be as harmful. If you decide to go for public consideration of some of the other sites, I repeat, we have signed non-disclosure orders, and there is information and there is damage to be done if you take that in the public domain tonight.
Councillor Blackmore.
Sorry, Chairman, I moved my microphone away because I thought we were going to private session. I think there are several things here. One, I've always been an advocate of transparency, and I think that's the way we should operate. However, I think there are other principles that we've kind of glossed over. We're actually looking at the overarching strategy of this decision, the principle. We're actually not sitting here and picking in fine detail at every single site. That is not the purpose of this meeting. And I feel as if we do this a lot here, and I find it so frustrating. We start digging around in the weeds when actually we shouldn't be doing that. So I accept that lots of people want to talk about individual sites, but that's not really the purpose of this meeting. The purpose of this meeting is to say, do we agree with these principles? And if the answer is yes, great, it goes forward. And if the answer is no, then they don't go forward. In my opinion, it's as simple as that. We're not talking about individual planning applications. We're not looking at numbers associated with individual planning applications. We don't have outline planning applications. That is the domain and the department of what planning does. That's not what we do here. When strategic planning meets, they can then distill all the facts. But at the moment, we are looking at it as the council has a register of assets. And we looked at some of those assets a while ago, and this is part of the distilling of those assets. That's what we're looking at. We shouldn't be getting bogged down in picky little details. So I do accept the Chief Exec's advice. As I say, transparency, I think, is incredibly important, but I do feel as if we're digging in the wrong hole at the moment. So if we could just take it back up to the strategic level, I'd be deeply grateful, Chairman.
Thank you very much for your wise words. Councillor Chapelty.
I think the executive summary puts it rather well. In terms of decision making, it's important to understand in this process the council wears two hats. For the purpose of this report, and this report only, the decision to be made, we are wearing the property hat. Anything to do with planning should definitely be carried out in the public domain. However, we approach this as a landlord and a potential landowner. We would not expect any commercial landowner to hold any sensitive discussions in front of us, and therefore, as property owners or potential property owners, I do not feel we should be discussing things that affect our commercial interests in front of other landowners. I therefore propose that we move on to part 2.
Thank you very much. I had one person indicate. I will take you up on that. I'll just go to Councillor Mackay for a last word before.
Very quickly. Chief Executive indicated that when would be appropriate, when would the information be available for public? You understand what I'm saying?
So I think the first thing to say is that transparency is a very important issue, and we do not make recommendations to take things in part 2 lightly. And I think it's also fair to say that it's worth perhaps segmenting the information in this report into 3 categories, from the least to the most sensitive. So the fact that we own property and we own the sites that are listed in here is in the public domain anyway. If you make a decision this evening that any or all of those sites would go into the call for sites, that information can go into the public domain quickly. If you make a decision with respect to the regeneration sites, I think the same would apply. For the third category, the same would not apply. We need to establish with you a principle about that third category. If your view is not to pursue that idea, I'm choosing my words carefully, then the likelihood is that the information would never go into the public domain, because you would say, we don't want to do this. If you decide that you do wish to pursue the idea, then we will need to work very carefully with other people in order to manage how that information does go into the public domain. I do not want to be in a position where this authority and me, because I feel I've got some obligations have been created where we breach those. I think that would be extraordinarily unhelpful to this authority. So that's why I'm differentiating between the three different categories. And I do very well understand, and I want to join with you in wanting to put as much information into the public domain as soon as we possibly can.
Thank you very much. So I proposed, and actually 2 people sort of seconded and thirded, that we would go into part 2 for agenda item 10. I will ask again for a show of hands. Is that agreed? We go into part 2. And those against? Abstaining? 1. So we will move to part 2 for exempt item 10.
Apologies, sir. May I ask for my dissent to be noted?
Same myself.
Okay, thank you. Agenda item 8, presentation of any petitions. There are none. Agenda item 9, there are no questions from the public at this stage. I would now like to ask our committee clerk to turn off the webcast before we move to agenda item 10.